Good evening, everyone. Can everyone hear me? Good evening. Please, if you can hear me, please indicate by just in the chat box, just say something, respond, raise your hand so that I can know that I'm not alone on the call. Thank you. Do we have mentees? Yes, thank you so much. Thank you, Favor. Thank you for joining us. Thank you, everyone. I can see we already have a few mentors on call. Thank you so much for joining. Thank you so much for joining, Mrs. Osiri. Thank you, Mr. Nachan, for joining. We'll be starting right about now. And welcome to the first official class for the JIIPCC mentorship program for alternative dispute resolution. We'll be commencing the session right about now. I want to welcome you. I will be your moderator for today. My name is Dennis Williams, and we'll be starting off with a few announcements. So our first announcement is that registration is still ongoing for those who are still interested in the program, right? If you have friends who are still interested in this program, up to the second week, we'll be continuing with registration. So you can send the link. This is our flyer. You can reach out to me for the registration link and we'll send it to you. Please ensure to send or to share with your friends and your family, right? Tell them that JIIPCC is doing something new, JIIPCC is doing something exciting. This is an entirely new course and we expect that it's going to be a very, very, very wonderful time. We are going to have rather a very, very wonderful time. Okay, and also for those who wish to make payments, that is for the students who joined using the free slots. You can still make payments if you want for the certificates. Yes, it is very optional, but if you would like to have the certificate at the end of the mentorship program, please do well to reach out to me and I would get over the details of the account details to you so that you can make payments. Thank you very much. And okay, now we'll be going straight into introduce our mentors for today. We'll be going straight into that. And our first mentor for today is none other than Mr. Nyachan Namwan. Mr. Nachan Namwan, who happens to also be the executive director of the Settlement House ADR Training Institute. We are working in partnership with the Settlement House Training Institute, SHATI, right, to bring this program to you. I want to thank our mentors from that platform who who have volunteered, right, to bring together or to put together this amazing session alongside JIIPCC. We say thank you very much. So I'll just go straight to reach Mr. Nasham's profile. Mr. Nasham Namwan is a lawyer and the principal partner of the law firm N. Nyacham and Co., a law firm based in Kaduna, Nigeria. He is a certified teacher, trainer, and facilitator. He's a faculty member and the executive director of the Settlement House ADR Training Institute, SHATI, an institute for training, certification and practice of alternative dispute resolution. He is also a member, as well as a faculty member of the Nigerian Institute of Chartered Arbitrators, a model arbitration certification institute in Nigeria. He is a certified dispute resolution specialist, an international mediation campus training mediator, an attorney mediator, a certified mediation advocate, an arbitrator, a certified negotiator, an ADR practitioner, a restorative justice practitioner, and a certified emotional intelligence specialist. He is a certified conflict manager, a certified ADR registrar and / secretary, a holder mediator academy, or a holder of Mediator Academy, United Kingdom Certificate in Commercial Mediation accredited by Institute of Chartered Arbitrators, UK, a medical law enthusiast, an employment and labor law expert. He is accredited and trained mediator with Accord Accords International, India, and completes a course of becoming a Florida Supreme Court certified county mediator in the United States of America. He served as a judge and expert assessor in many international mediation and negotiation competitions. He has mentored many students and non-students in the theory and practice of ADR. He has keen interest in the application of ADR in the resolution of medical and negligence disputes, workplace disputes, commercial mediation, faith-based disputes, land disputes, family disputes, amongst others. As a dispute resolution specialist, he has handled several disputes which were amicably settled out of court. Even he is ever willing and ready to volunteer for the and contribute to the development and practice of alternative dispute resolution. He is a facilitator and professor and a professional diploma for the professional diploma in education of the Institute of Education, Ahmadu Bello University Zaria, as well as an external facilitator with the Federal Polytechnic of Kaduna. He is married to a female, to his wife, and they are blessed with 2 children. Our next mentor, thank you so much, sir, for joining. Our next mentor for today is Mrs. Miriam Osiri. Sorry for my pronunciation, ma. Right, I'll just go straight to her profile and I'll try as much as possible to be very, very fast. Miriam Osiri is a barrister and solicitor of the Supreme Court of Nigeria with a Bachelor of Law degree with specialization in private law. She is a senior associate of M. Osiri and Associates, a law firm which focuses on corporate/commercial law, property, real and intellectual law, and family law. She's a certified dispute resolution specialist and a promoter of alternative dispute resolution as a more sustainable method of resolution of disputes and administration of justice in Nigeria and in Africa at large. She has skills in mediation and intervened in settling disputes within the family. She's skilled in mediation and has in settling disputes with family sphere. She is also the convener of the virtual hangouts where family issues are discussed and solutions recommended within the family and business sphere. She is the author of the book Preserving Business Relationship Beginner's Guide. She attended Business Management Masterclass under the WIN program organized for youth by the Federal Government of Nigeria, and also holds a certificate in project management issued by PEX Foundation, an organization that specializes in providing business development and consulting services through its business arm, iCenter Consulting. She is currently undertaking her Masters of Law program at the University of Abuja, Nigerian Department of Public and International Law, the student of the Institute of Chartered Secretary and Administrator, and also is out as the Financial Secretary of the Bar Association. She is a faculty member of the Settlement ADR Training Institute. Her hobby are singing, listening to music, cooking, meeting new people. She is also an advocate of good governance. She is happily married with 2 lovely kids. Thank you, Ma, for joining us. We'll welcome you to today's program. Our third mentor for today, and I will try as much as possible to just summarize her profile so that we don't take so much time reading profiles. Our next mentor is Miss Lolia Dil Oligbo. Sorry, ma, for that, my pronunciation. Lolia Dil Oligbo is an accredited attorney, mediator with the Lagos Multi-Door Court House. She is also an accredited mediation advocate with the Standing Conference Mediation Advocates UK. She is the founder and principal partner at Miltale Legal Practice, a full-service law firm with a strong focus and a comprehensive knowledge in the area of commercial law and mediation. In addition to practicing law and mediation, she is also a facilitator and trainer with Miltale ADR, in addition to Miltale ADR, where she conducts training in areas of workplace conflicts management of organizations, companies, and SMEs. Other areas of interest are customer conflicts in the hospitality industry, as well as being a conflict coach. Just list this last, in summary, I was just reading this last sentence here. Lolia has a keen interest in the promotion of online dispute resolution to help businesses and individuals resolve issues without recourse to litigation. Thank you so much, Ms. Lolia, for joining in. I'm sure our mentees have gone through your profile, right? It has been sent to their group, and they are well informed of our wonderful mentor who is here with us. Our fourth mentor for today is Ms. Baratu Johanna Dangana. Baratu Dangana is passionate about dispute resolution as well as core legal practice. Her desire is to see that disputes are resolved amicably in our society. Propelled her to enroll and become a certified mediator and arbitrator. She is a full member of Settlement House ADR Training Institute, an institute for training, practice, and certification in ADR. She is also a full member of the Nigerian Institute of Chartered Arbitrators, an institute that trains and certified arbitrators and mediators in Nigeria and holds a master's degree in law. She was called to the Nigerian Bar in 2007 and currently a senior associate at JB Dauda San and Co. Kaduna, Nigeria. She has expertise in labor-related matters and has successfully published articles such as character evidence in criminal case, final year project at Usman Fojo University, Sokoto, 2006, the role of the National Industrial Court of Nigeria in resolution of labor disputes in Nigeria, challenges and prospects, seminars, papers, unfair labor practice and their legal effects on termination and dismissal of employment in Nigeria and Ghana. She is also a member of Nigerian Bar Association, International Bar Association, Commonwealth Lawyers Association, and has attended conferences organized by this prestigious body where she has gained enormous experiences. Thank you, Ms. Baratu Dangana, for joining us. We are happy to have you on call. Our last but not least on our mentors list for today is Mr. Samuel Orobusa or Sareren. Mr. Samuel Orobusa or Sareren is a mediator, an arbitrator, a peace advocate, a negotiator, and a distinguished ADR practitioner to the core. He possesses advanced knowledge and understanding in peace and resolution, advocacy, community mediation, family mediation, workplace conflict management, and solution peace building, amongst others. He is a minister of God. He holds a PGD in theology from the Redeemed Christian College, a graduate of the Word of Faith Bible Institute, WOFB, in the Living Faith Church, a lover of peace and the youth. Osanre is a graduate of banking and finance from the University of Benin, Uniben. He has passion in advancing the gospel of ADR, which accounted for his willingness to volunteer and facilitate various means of peace and amicable dispute resolution. I'll just be reading this last few sentences and we'll be going straight into the business for today. He is the principal consultant of Persecuris, an associate consult, and the founder of Rehoboth Encounter Prayer Group. He is a certified peace and security consultant, a chartered human resource consultant, a fellowship of the Institute of Chartered Mediators and Conciliators, a member of the Resolution Specialists of Institute of Chartered Mediators and Conciliators, ICMC, ODR panel of neutral. He is also a member of the Institute of Chartered Administrator. He's a faculty member of the Settlement House ADR Training Institute, and Nigerian Institute of Chartered Arbitrators. Thank you so much, Mr. Samuel, for joining us. We are happy to have all our mentors on call. We thank you so much for everything that you do in terms of your contribution to the success of this program. And we'll be getting into the business of today. As we have earlier scheduled, before we go, we receive our mentors and we have their session. Just to spare time, we would like to call on our mentees to have their presentation first. We are trying to do this in order to cut or to save a lot of time. So please, we would like to have the Group 1 presenter for ADR to come up with their presentation, or to come up with Group 1's presentation, so that we can get to the other business. So Group 1 presenter, if you're ready, please, you can make your presentation.
All right. Good evening, everyone. My name is Ahmed Odudu, and I'm the presenter for Group 1. I'm just going to go ahead. Can you hear me?
Yes, thank you, Ahmed. We can hear you. Please, if you may, can you kindly turn on your video so that we can know, we can see you, and then when you're ready, you can share your slides.
Okay. So, like I said, my name is Ahmed Odudu, and this is the face to the name. And I'm really excited to be part of this program and this cohort. Over the next few minutes, I'm going to be presenting on the overview of ADR, its history and guidelines. So I'm just going to go ahead to turn off my camera and share my screen and make the presentation. Thank you. Okay, straight to the business of the day.
I'm sorry, we can't release. Okay, we can just screen.
Okay, straight to the business of the day. So we are asked to make an overview of ADR, its history and its guidelines, and I'm representing Group 1. As we may all know, ADR is the abbreviation for Alternative Dispute Resolution, and basically ADR is a way of settling conflicts or disputes outside the traditional court systems. So ADR in its purest form, or will I say in its original form, it's as old as mankind, in the sense that man has always been in conflict with himself and in conflict with people around him, and man had the need to devise a mechanism that will resolve these differences. So ADR is very old, and this ADR can be traced back to ancient civilizations such as Greece and Rome. Even in Egypt and traditional African societies at one time all practiced ADR. One of the common things among these civilizations is that they always kind of had like a symbol of authority or leadership. And like in the traditional African society, most of these symbols of authority are usually like the household head or clan head. Sometimes it could be village or helmet head or district head or councils of elders. So when there are disputes in communities or in households, they present these disputes to these symbols of authority. And at the time, they gave, they made resolutions and gave decisions based on what they thought was, the best for them at the time. So ADR has always been in existence in its purest form. But I would like to mention that ADR as a concept became more prominent in the 1970s or the 20th centuries, when the courthouses became very jam-packed. Cost of litigation became very cost, and of course there were other needs to exploit other ways to resolve conflict. So ADR at the time became popular when it was promoted as a concept by legal systems and government. So when government and legal systems across the world saw how effective and efficient ADR was, they embraced it, and they started promoting the use of ADR, and here we are with ADR today. So ADR in ADR has 4 basic categories, and these categories are mediation, arbitration, negotiation, and conciliation. So I'm just gonna go ahead to just say 1 or 2 sentences about what mediation is. So mediation normally is when the conflict in disputes present their facts to a facilitator, usually called the mediator. So the mediator in this case guides the party in conflict to make a decision that is best for them. So basically, that's what mediation is. Then arbitration is similar to mediation. Arbitration also, parties that are in conflict are facilitated. Communication between parties in conflict are facilitated by an arbitrator or a panel of arbitrators. After hearing and observing evidence and facts presented by the parties in conflict, the arbitrator or the panel of arbitrator goes ahead to make a decision for the parties in conflict. I did quickly like to point out that while in mediation, the mediator guides the parties in conflict to make a decision that they perceive is best for themselves. In arbitration, the arbitrator or the panel of arbitrator gives a decision that is binding on parties that are involved in conflict. That takes us to negotiation. So negotiation is also a form of ADR that parties involved tend to communicate directly between themselves without a facilitator and reach an agreement that is best for themselves. And usually this kind of negotiation usually is carried out between people that are in business or people that are making claims for personal injury. Then conciliation is also a process of ADR that is facilitated by a conciliator or a commission of conciliation or a commission of conciliators. Conciliation is very similar to mediation in the sense that they also present their facts, and the commission goes through it. The difference is, I think mediation is more informal than conciliation. Conciliation tends to be more formal than mediation. That takes us to the guidelines for ADR. And the guidelines for ADR proceedings are voluntary. They are neutral third party, they are confidentiality, they are informal, and they are flexible. Now, ADR is voluntary in the sense that all the participants or parties involved agree to engage willingly in the proceedings. It's not like the traditional court system where if you are served and you don't appear, the court can hold you in contempt. So in ADR is voluntary in the sense that everybody that is involved in the conflict agrees willingly to engage in the proceedings. Then in neutral third party, the neutral third party is usually the mediator or the facilitator, the mediator, the conciliator, or the arbitrator. And they are usually unbiased and should be able to communicate in clear languages for everybody, for all the parties in conflict to understand their decisions. That takes us to informality. ADR is also informal in the sense that it's less formal than the normal court proceedings. And this usually creates an atmosphere of relaxation where you feel more relaxed, and it makes dialogue and the proceedings very, very easy. It's not as formal as the traditional court system. Then flexibility. ADR is very flexible in the sense that it can be tailored to specific circumstances or unique cases. Let's say, for example, let's say for example, a certain parties in conflict are from a certain ethnic background in Nigeria, and they have decided to go the ADR way to settle their disputes. In the traditional court system, of course, English is the formal language of Nigeria, so um, cases are normally heard in English. But in ADR, if of course, if the parties involved agree that such proceedings should be carried out in their local dialects, it will be carried out in their local dialect. So that's how flexible. That's the flexibility part of ADR. Then a classical example of arbitration case is the British Virgin Island Company. Now, well, I'm not sure about the facts of this case, but I'm not sure about the facts of the case, but it was between BVI and Nigeria, and I think it was about a failed gas plant. But they went the ADR and the English High Court handed down a landmark decision on the 23rd of October 2023, setting aside 11 billion arbitrator award against Nigeria. So basically, this is what we are able to come up with as a group. Thank you very much.
Thank you very much, Mr. Ame, for that wonderful presentation. It was fast, it was precise, and it was straight to the point. I want to say a big well done to you for taking up the responsibility to present, and also to your group members for also putting together this wonderful presentation. Well done to you. I also want to see responses from your group members saying well done, Mr. Ame, for that wonderful presentation. So we would like to call on, you can stop sharing your slide now. We would like to call on the next group to present, that is group 2. Please, you can also, the group presenter can also come up and make, you can also come up and make your presentation. Please, the presentation time is 7 minutes. We would like to have that so that we can get on with the rest of the program for today. So group 2 presenter, please, if you are ready, the stage is yours for your presentation. Group 2 presenter. Please, if the presenter is not available, can the backup presenter fill in so that we don't waste any time?
Good evening, class.
Yes, good evening, Mr. Richard. Thank you for joining in.
Okay. My name is Richard Kaikinge from Benue State University. I am glad to announce my presence here this moment, and I want to really sincerely appreciate the persons who have actually put this platform together for all of us to learn this moment. So let me go straight to the point. I am here to make the presentation on behalf of Group 2. And what I am actually supposed to present on is basically alternative dispute resolution, its history and the importance. So one of my team members will be sharing his screen with us all so that we'll be going through what we have been able to put down together as I make the presentation. Thank you, everyone. Hello.
Please, the person who's supposed to help share the screen, please, can you go ahead and help with that? Okay. If you're finding it difficult sharing your screen, I'll just go ahead and share the screen. But Mr. Richard, please, you can go ahead with your presentation. You can start. I would get the presentation up right now.
Okay, thank you, sir. So basically, alternative dispute resolution, as we all know, is a non-adjudicatory form of dispute resolution. And just like the first presenter had already stated, this is a form of dispute resolution which has always been there for us, right from when we had no contact with the Western or the whites before the introduction of the moot or the court activities. And for example, here in my place, prior to when we started litigation as a form of dispute resolution, we had a system on ground whereby when individuals had issues, they come together, the elders of the family or the elders of the community will come together, settle them with the hope that after the settlement, their relationship was still going to be intact going forward. However, it is recorded that alternative dispute resolution actually started in 1066 in England, and then subsequently it spread to the United States in the 1970s, and further further on spread to places, other climes like China, Philippines, and what have you. Here in Africa specifically, it is on record that alternative dispute resolution actually started or actually was noted in the 1980s and 1990s. And more specifically in Nigeria, it was in the 1990s. And this actually received, the first time it received statutory flavor was in 1999, that is under section 19, paragraph D of the Constitution, which is to the effect that resolution of disputes amongst the international communities should be by negotiation, arbitration, conciliation, and mediation. So with that, we have already come to the end of the first session, which is the history of alternative dispute resolution. So now we'll be going into the importance of ADR, and it has a myriad of importance, but it has a myriad of importance, but we'll be highlighting the following. First, it is less time consuming. It is less time consuming in the sense that under alternative dispute resolution, the persons who are involved, they get whoever it is, either the mediator, the conciliator, or the arbitrator, who is supposed to negotiate with them, help them settle their disputes. So as these people come together, there is usually no case or no movement of parties from one place to the other, or there are no so many adjournments as it is usually done when it comes to litigation. So as a result, the time frame that is actually taken in the resolution of such disputes is usually minimal as compared to litigation. Also, it is less financially involving in that when it comes to litigation now, the filing processes, appearance of lawyers and the parties themselves, sometimes one is staying in a different town. Meanwhile, the case is supposed to take place in a different time. You have to be traveling up and down. Therefore, you have to be incurring financial expenses. But when it comes to ADR now, just within the same community, if you are able to find an arbitrator or a mediator, the matter is usually resolved without all the necessary movements being involved. And also, the number three importance of it is that when it is in a litigation process, it is usually or basically after the matter has been concluded, the relationship of the parties is most likely being tampered with. But under ADR, in most instances, or let me say in all situations, after the matter has been resolved, the good relationship of the parties is still maintained, because right from the beginning, the arbitrator or the mediator is always mindful of the fact that these people he is appearing to, help them resolve a matter, still have a relationship to maintain afterwards. And so these are just a few of the importances that we'll be talking about, or I have chosen to talk about here this moment. Thank you all.
Thank you so much, Mr. Richard. I sincerely apologize for not being able to help share your screen or share the presentation with everyone. I had issues accessing the documents, and I kindly apologize. And thank you so much, Group 2, for putting together that wonderful presentation. Thank you, Mr. Richard, for also delivering it very, very well and in time. Well, I want to see reactions from your group members saying a job well done, and a job well done to Group 2, like I earlier said. All right, we'll be taking our picture time now, since the time is quite late, and I know the weather is becoming, or the lighting in our different location is becoming poor, right? So that we can, or I can get to see everyone's face. Please, can I request that everyone turn on their camera so that we can take a quick picture before we go into our mentor section? Thank you. Please, if you can, I want to see people's camera turn on, right? All our mentees, if you can, turn on your camera. All right, thank you very much. We'll be doing this very fast. I want to see more mentees turn on their camera. Thank you. Okay, yes, and we are done with that. Thank you. Thank you very much, everyone. And all right, so now we'll be going straight to getting to hear from our mentors, right? I'm sure they have quite a lot in store for us. And I know that we, the mentees, are itchy to hear what they have to tell us about ADR. I would want our mentees to also kindly have a pen and a biro with them if you can, right? So that you can take down points and also prepare questions to ask our mentees, to ask our mentors rather, so that we can have clarity on maybe some misconceptions that we may have about ADR. So I would like to call on our first mentor, right? Ms. Baratu Dangana. Please, Ma, the floor is yours. For we want to hear from you on the overview of ADR, Ma. Thank you, Ma, for joining us.
Thank you, sir. Maybe I will be assisting you from now hence, so that we can
to everyone.
Dennis, can you hear me?
Can you hear me?
Mr. Nachan, yes, I can hear you.
Yeah, so I will be assisting you from coordinate this particular aspect. So you just relax, okay?
All right, sir. Thank you very much.
Yeah. Thank you. So let me first of all appreciate all the mentors who are here present. We appreciate you. JIIPCC appreciates you. Settlement House ADR Training Institute appreciates you. We are really happy and excited to have you here. My name is Nanchang Nangwang. As I was introduced, I am the Executive Director of Settlement House ADR Training Institute, and I am actually happy to be here. Now, we have had your presentations, and then we feel there is we want to present something that will put to perspective some of the things you have shared. Let me commend the mentees for what they have done, the research they have done thus far. I think they have done a very wonderful a wonderful job. So I'm very excited. I can see the research they have made. And can you confirm if you can see this screen?
Yes, I can
Yes, sir.
see.
Yes.
Yes, I can see the screen.
Yes, I can see the screen.
See it too.
Okay. Let me stop sharing. All right. So Baratu, you're going to be taking us on the coming. Just a minute. Wow. All right. Good. Okay, so here we go. Can you confirm if you can hear me?
Yes,
Yes,
sir, we
I
can.
Yes, we can hear
Yes,
you.
sir.
Can you confirm if you can hear?
Yes, sir.
Yes, sir. We can hear you.
Is that not good? No. She's the one, but
Okay, that's good. So Ms. Dangana, you're going to go first, and so you're going to take us briefly on the history, of mediation, how it comes about, and all of those things. So you start by defining, a little definition, then you go into the history before we proceed. I will be calling in the mentors to share their perspective on those aspects, and then we can make general comments. Thank you very much.
All right, thank
You're up.
you. Thank you very much to everyone, and good evening. Now, for us as mentors, we are happy to have all the mentees, and we are looking forward to these mentees also becoming mentors and becoming experts in alternative dispute resolution. Now, we are looking at history of ADR and mediation. And so ADR is one aspect of mediation, or mediation is one aspect of ADR. So generally, alternative dispute resolution is a mechanism used to decide or settle disputes outside of litigation. Now, when you look at historically, you see that even the mentees have given their own perspective of what ADR is, as far as the history of ADR is concerned. And so moving forward, we'll be more particular to some extent on the history of mediation. And mediation, according to research, has its history from Australia and went to the United States, and then to the United Kingdom, and then to Africa, beginning from South Africa. So it is one aspect of alternative dispute resolution which has to do with parties themselves deciding their issue and resolving their issue. The mediator is only standing in as a middleman, and he is expected, or she's expected, not to take side on any of the parties, and to allow the parties to decide their issues and to resolve their issues on their own. So mediation is very, very key. Thank God in Nigeria now we have a law that provides for mediation. Before now, mediation was looked at as one of those alternative dispute resolution mechanisms that does not have legal backing. But now it does have legal backing. And so at the end of mediation, whatever the parties resolve, they are going to there is going to be a resolution for their disputes, they are going to be bound by it, by the law. And so it's no longer business as usual that you just come to the mediation table and then you decide on some issue and you go back and say, because the law will not come after me, I'm not going to do. Perhaps I am the party who is expected to do something in the settlement that both parties reach at. But because I knew that the law is not going to come after me, I would decide not to do it. It's no longer like that. So the ADR as a alternative to litigation is very, very important. And it is encouraging parties in every aspect of life to go beyond litigation. And then at the end of the day, mediation helps you to settle as friends. You don't end up as enemies, because this time around, it's not like I have won the case. No, both parties are actually the winners, because it is both of them that decided on how they are going to sort and settle their dispute. So for me, ADR has a history that is very good, and mediation is also very, very important because it has helped parties to settle their disputes, and it is also leading to parties ending as friends instead of litigation, which makes parties to go out and become enemies. So there are informal mediation and there are formal mediation. There is also negotiation. There is also other negotiation mechanisms that leads to ADR and that are part of ADR and that helps in resolving disputes. So as far as the history is concerned, I don't want to go into so much detail. Historically, ADR and mediation has come to stay, and it is a better way to litigation, because litigation, you spend so much years in the courts and sometimes you don't get your dispute resolved. But in alternative dispute resolution, of which mediation is a part, you end up resolving your dispute within a short period of time. And that helps the parties, and that ends the dispute in a short time. Thank you very much.
Thank you. Thank you. Thank you very much, Baratu. So shortly, just by way of summary, she has helped us to understand briefly about the history, just as we have shared on the platform. This thing started. Mediation is one of the more often used mechanism for resolution of dispute under ADR. So it started back then. And then when you look at the works of Dr. Agada Elechi, Why Mediation Works, this is one of the paper that was presented. You see some of the history, you can see some of the advantages of ADR all over there. So you look at ADR generally, we used to say that it's our own kind of thing. African way of resolving dispute. That's how one of my mentors referred to it, because you see that one of the group have mentioned, traditionally when there are issues, when there are disputes, you see people trying to resolve these disputes. They go before the elders, they go before the family heads, they go before people they feel possess the ability or what it takes to help them resolve these disputes. You can see them all there. So historically speaking, you see that both Christianity, Islam, all of them have traces of mediation. They have alternative dispute resolution. Now, when we mention alternative dispute resolution, it encompasses all the alternative way of resolving disputes outside of the courtroom. So when we make emphasis on mediation, we're talking about one of the most frequently used mechanism for resolution of disputes, and this thing has dated back to our pre-colonial communities, our grandfathers, they sit under the trees, they do all of those things. And you can see that both the Bible and the Quran and then some other religions around the world encourage the use of ADR, if you check. Now, when you come to Nigeria, like the mediation and the use of ADR, you see that the first the activities of the negotiation and conflict management group was one of the the activities or what brought about ADR, particularly in Nigeria, to the limelight, to life. And then you can see the Institute of Chartered Mediators and Conciliators who have started some of these things back then in the 90s. They started some of the training, the sensitization in alternative dispute resolution, though they are limited to mediation, particularly, and conciliation. That is as at then. Now, the activities of this NCMT gave birth to it gave birth to the multi-door courthouse. A multi-door courthouse is a court-connected ADR center. The multi-door courthouse is a court-connected ADR center, meaning that within the court premises, you have a center called the multi-door courthouse where disputes, whether it is mediation or arbitration, is being referred to from the court most times, although they also accept people on their own moving in, as in coming into the multi-door courthouse to file their cases. Then ICMC pioneered the activities of some of those things, ADR trainings and seminars as at then until now. We now came to where we are today. Now, when it comes to training, when it comes to ADR, we have a lot of institutions that have come into being. If it comes to arbitration, for example, you have the Nigerian-based institutions. Aside from the Lagos Multi-Door Courthouse, which trains mediators, you have the ICMC, which also train mediators and conciliators. And then you have the Nigerian Institute of Chartered Arbitrators. That's Nigerian-based institutions that train arbitrators mainly. They also do some trainings in mediation. Then we now have, among other ones, we have Mediation Training Institute Nigeria, and then we have the foreign ones like Chartered Institute of Arbitrators, United Kingdom, Nigerian branch, and several other ADR institutions that have come up. Recently, we now have the Settlement House ADR Training Institute in collaboration with the JIIPCC, which are now bringing this particular webinar or seminar. So Settlement House ADR Training Institute is one of the training institutes that it does not just limit itself to mediation or arbitration. It does training and certification in all alternative ways of resolving disputes, be it mediation, be it arbitration, be it negotiation, be it, anything that has to do with ADR. That is what Settlement House is being trained for, is being registered for. And then it has the mandate of the federal government, the Federal Ministry of Education to be able to, Federal Ministry of Justice to be able to do some of these trainings and certification. Why? Because we now have a situation where people are looking for alternative ways of resolving disputes. So having said so, I would like to call on, that's briefly about the history of ADR. So having said so, I want to call on Mr. Samuel. Mr. Samuel, are you here? I will implore the participants or the mentee take notes of questions, write down questions, that you may want to ask, eventually in the course of it. So, Mr. Samuel, can you briefly take us through the ADR spectrums? Briefly give us a little perspective on what they are.
Thank you so much, Mr. Nochang, and good evening to all participants. Please confirm if you can hear me clearly.
Yes, sir, we can hear you.
Yes,
I want
sir.
to thank the two mentors that has taken us on. Well, thank you so much. I want to thank the two mentors that have taken out time to show more light into the subject matter. I want to congratulate Group 1 and Group 2. Your passion is remarkable. Thank you for your detailed analysis and I do hope it will get better as the day goes by. Now, we are looking at alternative dispute resolution, and some persons call it affordable dispute resolution, others call it African dispute resolution. Some persons will call it appropriate dispute resolution. It talks about alternative ways in which dispute can be resolved. Will just happen a few of them. Let me begin with negotiation. Now, perhaps this happens to be the most common and straightforward form of alternative dispute resolution. As common as it is, as popular as it is very complex. Many concepts has their formal angle and their informal angle. Now, negotiation basically speaks to communication. Communication that is being instituted among parties that have disputes for the purpose of arriving at an agreement. Negotiation simply talks about the processes involved whereby parties can be brought together. Parties, people who have different perspectives, people who have different opinion on a specific subject matter, seeking to bring them together, exploring options to enable them arrive at a single opinion through the instrumentality of communication. We all know that communication is a process whereby information is being passed from a sender to a receiver through a channel and is being returned from the receiver back to the sender in form of feedback. When communication is effective, conflict becomes inevitable. So negotiation talks about a process where parties are engaged in creative discussions that will enable them to find a middle ground to bury any form of animosity for the purpose of forming a common cause. In negotiation, the desired objective is an agreement, the meeting of the minds. It may not be enforceable, but it is achievable. If we proceed further, looking at negotiation, there are people that are being trained to master the skill of negotiation to enable them emotionally and intelligently carry parties along, moving them from point A to point B. Point B is usually a position whereby differences are buried and the way forward is being worked upon. Another means we are looking, another spectrum we may likely look at is mediation. Now, permit me to say that most of these ADR spectrums, they are intertwined. We may not be able to isolate one from the other. Most of them are different pillars that have been erected to uphold the structure of dispute resolution. Mediation basically is a voluntary process. I usually put the word voluntary in quotes. It's a voluntary process in which a third party who is a neutral person, who is a qualified person, who has the necessary skills, assist disputants in resolving issues that bothers them. So mediation is a process, and in mediation, we also find negotiation. The purpose of mediation is to assist individuals navigate their way through all forms of storms, through all forms of conflict, because we've come to understand that perception in life is unique. Perception in life is dynamic. The most common example we use when we are looking at conflict Somebody sits on one end, he sees a 9, he sticks to that 9. This is what I'm saying. Somebody else sits at the other end and he sees a 6. True to his word, he's seeing a 6. And there's no way you will tell someone that is seeing 6 that what he's seeing is a 9. There's no way you tell someone that is seeing a 9 that is seeing a 6. So the fact is that my opinion is unique, but for the purpose of moving forward, if we all stick to our individual opinions, progress will not be achieved. Moving forward will not be possible. Now, when people are in conflict, it doesn't mean that they are wrong. When people are in conflict, it doesn't actually mean that what they are saying is against the other person. They are simply expressing their thoughts. But in expressing your thoughts, we should take into consideration that two persons can never be the same. Looking at the fundamental human rights, we all have our fundamental human rights, but we are being admonished that we should exhibit our fundamental human rights in a way that it will not infringe into the rights of somebody else. We are always being told that when a handshake passes the elbow moving forward, it is no longer a handshake, it's becoming something else. So mediation basically is a process that a trained third neutral person assists parties having at the back of their mind that perception, when different, will fuel conflict. Because of this, assist them, understand their differences, appreciate their differences, and encourage them on the need to move forward. We must understand that some conflicts may be resolved. Some conflicts may at best be managed. Either way, mediation has its own form of challenges, and I will encourage you to do more study into what it entails. Now, we have other forms of ADR spectrum looking at arbitration. I want to appreciate the different groups that took out time to actually look into this. Now, on a common perspective, people usually say that arbitration is like private litigation. Arbitration is litigation in a flexible manner. Oh, yes. Unlike mediation, there's no form of technicalities. We go straight to the point and see how parties choose to resolve their disputes. In mediation, it is a party-driven process. The mediator assists the party. The mediator is the ones that assist the parties in arriving at a decision that both parties are accountable to. The end of the mediation process is usually called settlement agreement if both parties decide to settle. But in arbitration, both parties make their submissions. They are free to present documents. They are free to cut witnesses. Almost every procedure being considered in litigation is also being considered in arbitration. But the difference is the timeline, the policies, the framework is at the instance of the parties. Basically, for all ADR processes, there's usually what we call the ADR clause. And this clause is what gives rise to the activation of any ADR process. Parties must have made up their mind in the eventuality of a dispute. We choose, all of us involved in this business, we choose to resolve our dispute through an ADR mechanism. In arbitration, parties are free to make submissions, present documents, make arguments, and at the end of the day, the arbitrator, if it is a sole arbitration process, or the arbitral panel, if it is more than one arbitrator involved, takes a decision on the matter. And the outcome of an arbitral process is usually called an award. In mediation, settlement agreement, if both parties settle. If both parties do not settle, it's called inability to resolve. In the case of arbitration, the outcome is usually called an award. And award talks about the understanding and the position of the arbitrator or the arbitral panel as touching that particular dispute that have been brought to them. I'm sure we have opportunity to throw more light into all these processes. Now, talking about conciliation, I may not want to spend much time in conciliation, but let me just quickly harp on this. Before last year, we had what they call the Arbitration and Conciliation Act. But as we all know, towards the end of the last administration, we now have what we call the Arbitration and Mediation Act. So to an extent, mediation is now in place of conciliation. Now, one of the major, there are three major differences between arbitration and conciliation. One of the major differences is that before now, arbitrators are not in any position to suggest ways of settlement to parties, but conciliators have the authority to suggest terms of settlement. But as it is now, mediators are empowered to inspire parties and suggest to them possible ways of settlement. So on a legal perspective, looking at the framework we have, what is being obtainable in Nigeria as it stands today is the Arbitration and Mediation Act. So I will quickly skip to MEDAB. MEDAB is a blend of mediation and arbitration. Remember, I don't view the different spectrums as which is better than the other. The spectrums are there to enable us conclude which of this spectrum suits this dispute most. Is it arbitration? Is it mediation? There's the possibility to begin a matter with mediation and proceed to arbitration. When disputants come before an ADR process, the dispute may be a reflection of one concern, or it may be a reflection of several concerns. If there are several concerns, it may not be possible during the process of arbitration that all the matters are resolved. May I submit at this junction that in mediation, at the end of the process, whether parties settle or not, parties may decide to settle, they may decide not to settle. You don't force parties to settle. But when the end of the mediation process of all the concerns, if there are 6, 2 or 3 of them were successfully settled, the parties can decide to proceed with the other pending matters to move them to arbitration for the arbitrator or the arbitral panel to make a binding decision on them. Now, please, let's quickly look at the other ADR spectrum. We have arbitration and mediation. We can begin from arbitration and move over to mediation. We have expert determination. Expert determination is a process whereby a professional in a specific field has the opportunity to make decisions and pronouncements regarding some specific matters. When the issue of paternity is in dispute, we all know that the easiest way of resolving that dispute is to seek the help of an expert determinator, a medical practitioner, to enable us determine who is the father of the child. We have early neutral evaluation. We have private judging. Early neutral evaluation is usually being said that when conflicts are handled at the initial stage, it prevents it from snowballing into a bigger picture. Private judging or judicial appraisal is a process whereby some matters are being explored. If this matter goes to court, what are the chances that any of the parties will succeed? This enables us to weigh the options before taking any form of decision. So these are the different ADR spectrum. They are not limited to this. It is much more than this. But as I conclude, I want to quickly highlight that there's no need exalting one spectrum more than the other. From what we are seeing, they are both intertwined. It is left for an ADR practitioner to look critically which of this spectrum fits this dispute. As a workman, there's tools. You may not be able to use one tool for every situation, but there may be a specific tool for a particular situation. I hope I've been able to guide you throughout this highlighted ADR spectrum. You're free to do your research, and you can take it a step further to become trained on either of these spectrums. You can become a trained negotiator, trained mediator, trained arbitrator. I want to appreciate you. I know I've spent so much time. Let me hand over back to our moderator. Thank you so much. Thank you.
Thank you very much, Mr. Samuel. Thank you very much. We're happy having you. Can you confirm if you can hear me?
Yes, please. We can hear you loud and clear.
All right, thank you very much. So these are just the mechanism. These are some of the different ways that you can resolve your disputes out of court. And Settlement House offers training in all of these mechanisms of resolving disputes outside the courtroom. That's why it is called an ADR Training Institute. Now, may I quickly call on Baratu? Let me call on Mariam. Please, Mariam, are you with us? You're going to tell us, you're going to look at some of the reasons why ADR is considered to be the most preferred means of resolution of disputes. So quickly, over to you. You have, let's say, at most 10 minutes.
Okay, good evening, everyone, and thank you for having me. So I'll just...
Thank you.
ADR and the history, and also the mentees have done an amazing job.
Hello, Mariam, can you hear me?
Hello, Nanchang. Hello.
Yeah.
Okay. Well, is it my network, because I have very poor internet at the moment? But I wanted
Go ahead.
quickly, yes, just to, because I'm afraid that my network might cut out at some point. But just to quickly add to the conversation while I'm still here. First of all, good evening, everyone. And just want to appreciate the parties, or rather the the team that took part in this. You can see that your research has really come through. Well done to you on that. I know that we're looking at the theory part of mediation here, and it's essential, obviously, to know the theory, how mediation works in theory. But I just wanted to highlight how it comes across in practical, in the practical experience, the beauty of mediation when it comes to the parties and how they receive, the process, because when we're in the process of mediation, not only do the parties benefit from the resolution of their disputes, but they also acquire some skills, an experience that at the end of it gives them the opportunity to practice it even in life. It's almost like a life lesson. So things like listening, people come into mediation not wanting to listen. They want to be heard. They want to talk. They want to be the one speaking all the time. But the process of mediation actually teaches people how to listen to the other party, how to listen to the other person's perspectives, their issues, their concerns. So you find the parties through the process learn how to listen to each other and learn how to understand each other's perspectives, which is where, it teaches them how to be to see where the other person is coming from, that person's perspective, and how the dispute has evolved through the fact that they've not been listening to each other. Most of the time it's poor communication. And so that is one of the things that parties learn how to do through the process. They learn how to listen more effectively. In the course of listening more effectively, they're able to obviously find common ground. Okay, what are the issues or the things that we can agree on? Where do we have shared interests that we can now even make compromises in order to reach a resolution? So, they learn how to do that as well. Even in resolving problems, problem solving, it helps them develop a problem solving attitude, because obviously once they find that I understand this person's perspective, I understand where the dispute has arisen from, and now how do we solve it, together? They start thinking outside the box for solutions. These things are things that these skills or these attributes or this experience is something that is useful within the mediation setup, but is also something that they acquire after the mediation has been done and can be used in everyday life, because we already know disputes is inevitable. We experience disputes on a daily basis, but how do we apply what we've learned through the mediation process? It also helps people build trust in each other. You form a bond, through the process, which is why one of the main benefits of mediation is that it preserves relationships. So all of these things are things that in practicality, you actually see it happening. As much as we're talking about the benefits of mediation towards the dispute, there are also benefits to the parties as well. So it's not just them coming and having a successful resolution, it's also, leaving a mark on their experience of the mediation process. And I just wanted to highlight that as we speak about, the theory of mediation and history and the processes and all of that, that we don't forget the parties and how they experience the mediation process and what they even walk away with, the experience that they have. So that was just my 2 cents there, because I'm worried about my network cutting out. So I just wanted to pitch that in whilst I'm still online. And apologies, please, I couldn't turn on my camera either because my network is quite pitchy at the moment. It's quite on and off. Hello?
All right, thank you very much, Lolia. Oh. Thank you so much, Lolia. We are going to get to hear about we are going to hear from Lolia later on in some of the other sessions. Thank you for making your contribution. Now, Miriam.
Yes.
Are you with us?
Yes, I'm with you. I apologize. It's raining heavily here.
Okay,
so
sorry.
The network.
Wow, yes. That's interesting. Rain. Yes. All right, go ahead, please. So,
okay, so
quickly.
I mean, bulk of what I intended to share has been discussed by the previous mentor, but just to add that for mediation, because I intend to share with us some of the difference between the mediation and arbitration.
Why is ADR? Can you hear me? Why is ADR preferable? Why do people, why should they say? Yes.
Okay.
So, go ahead.
Mediation, for instance, is somehow preferable to arbitration in some instances, and then more so because parties get to the table and decide something for themselves voluntarily. That is for mediation. So you don't experience the same thing when you go for arbitration, because the arbitrator in that instance is the one who hands down his award to the parties. And at the end of the day, you see parties still coming back to, appeal the award and say that maybe he was biased or he exceeded his jurisdiction in the process. But generally, ADR has enjoyed a lot of patronage in recent times because it has proven to preserve relationships generally between the parties. And I just want to add this to say that ADR is a mindset, right? So as ADR practitioners, we need to have this mindset that proposing ADR in the process of trying to settle a dispute doesn't mean that you're a weaker party. Because in practice, you find that when people are usually laid back to propose ADR because they don't want to be perceived as being weak or not being able to know what the law is, or just not being firm with their positions. So just to say that it is tested and trusted, right? So you don't expect to have the same mindset with a criminal lawyer, for instance, who is set in his ways in the area of proving beyond reasonable doubt, whereas you're proposing a more effective you should be able to develop
Miriam, can you hear me? Okay. So Miriam has Lolia and Miriam has helped us to see some aspects, some things about ADR, the advantages it gives you, the ability to listen. Parties in dispute more often they don't pay attention to anything, and then we look at the aspect of preserving relationship. ADR gives you that because you decide more often than not the outcome of the decision or how you want your matter resolved, and then you decide in almost all the instances, you decide who represents you, you decide the mediator, you decide the arbitrator, you decide every other person that is going to be involved in the process. So it's actually private and confidential. Whatsoever you discuss in the course of mediation or arbitration remains within the parties, remains it's not disclosed. It's not like a concession where somebody just come in or apply for the records of proceedings. So that is the voluntary nature. You are not forced into it. You will not be forced into it. You enter voluntarily. You have to I am entering voluntarily, and you see the process is actually.
Hello. Can you hear me?
Mr. Yanshan.
Okay.
So your network is kind of bad, sir.
Is it Mariam?
Yes, I'm
Mariam,
back now.
are you
the
back?
network is seriously fluctuating. Yes.
Okay, so okay. Can you see the screen?
Yes.
Yes, please.
Okay, so just briefly round up.
Okay.
I've talked about voluntariness. I talked about ownership of the process, and then maybe parties being treated with respect and all of those things. So look at it, and then we go on.
Definitely treated with respect.
Okay. I think our network, is raining over there. But participants, can you confirm if you can hear me?
Yes, sir, we can hear.
Yes, sir. We can hear you, sir.
I hear you.
We can hear you, sir.
So we're saying that it's preferred because parties will like a situation where they are involved in their dispute. For example, the judge decides everything. When you just give your evidence, they just decide, this is my judgment. But when it comes to ADR, you choose, and then you are treated with respect. Oh, sir, can you tell us your perspective? At the end of it, they will seek your opinion as to what is the decision that is going to be. What is it? You are owing so person 100,000 naira. Can you will you accept if the person pays you like 50,000 naira, and then the other one you have forgotten, or you let leave, and all of those things? That is only that happens only in ADR. So from the beginning to the end, that is the good thing about. So, and third party neutral is impartial. You don't go to one side, you don't favor another person, you are just there facilitating or helping the parties, and then you can see that it is affordable and less expensive compared to litigation, which you start the journey and you don't know when you are going to finish. ADR gives you opportunity to decide that this thing is going to finish within 1 week. So let's keep sitting and sitting. That's one of the advantages. Then you see, there is this creativity when it comes to solutions. Somebody will be owing you 10,000 naira, and you say at the end of it, I don't have money, but I have good. I have yam. Will you accept it in exchange for that? And then you see that is done. You have a solution, which is outside of what you ever imagine. ADR gives you that opportunity. Even in arbitration, which seems to be more formal, there is opportunity for parties to actually settle and then come in to do come and file their own terms of settlement if they are. Let me put it that way so that you understand, before the arbitrator, and ask him to adopt it in his award, and that is done. So you see, okay, agreements are reached, could be filed and adopted in court. So, and once that agreements are reached and they are filed in court and adopted, they become binding. You cannot even appeal it unless where there is fraud, which is actually difficult to prove, because before you enforce it, the judge or the ADR judge will want to find out whether that is what the people have agreed voluntarily, and when you accept, then they can enter it as consent judgment, and once that is done, it's very difficult for you to appeal against such decisions. So these are some of the reasons why people actually, I think people should go for ADR, should go for mediation, arbitration, negotiation, instead of issue of going to court and being battling. So Mr. Samuel, are you still with us? Mr. Samuel?
Yes, sir, I'm here.
Mr. Samuel?
Yes, sir, I'm here. I'm here.
Is Mr. Samuel with us?
Yes, please, I'm here.
Mr. Samuel?
Yes, please.
Okay, thank you very much. Please, can you quickly take us through types of mediation, the different aspects of mediation that somebody can get into,
Thank you so much, Mr. Nachan.
Mr. Samuel, go ahead, please, quickly. Let's say 5 minutes.
I have 5 minutes.
We can't hear you.
You can't
we
hear
can't hear you, sir.
Please, can you hear me?
We can hear him.
We can hear you, Mr. Samuel.
Thank you so much. So within 5 minutes.
Please, can you hear him?
Yes, we can hear Mr. Samuel.
All right, under 5
Dennis,
minutes.
Mr. Dennis, can you hear me?
Yes, I can hear you, sir.
Under 5 minutes, let's quickly look at the different forms of mediation. We have community mediation. Now, we all know that it is uncommon to have disputes involving one community and another. Boundary issue, land issue, a lot of issue, quest for resources. Yeah. So community mediation involves mediation on a large scale, mediation between a community and another community within one sovereign state. Some persons have been trained into what we call managing communal conflicts. So there's a branch of mediation that talks about communal conflicts. Now, usually when there's a communal conflict, we see both parties getting individuals to represent them. It is unfortunate that most persons that get appointed into such responsibility are usually politicians, but actually we should have communal mediators being saddled with this responsibility. We have neighborhood mediation, bringing it down to lower scale. Now, within a community, there may be conflict within members of the same community, within a clan, within a family and the other, within persons from different families within a community. The first one talks about more than one community. The second one talks about within a particular community. Mediation, an ability or a process whereby differences are being streamlined for the purpose of moving forward within neighborhood, family mediation. We get to see this every now and then. Towards the end of last year, I was appointed to mediate in a matter. The matter has been on for over 2 years. And this family made up of 3 gates and 20 children. Their father had passed on. Their father was a chief. He had passed on. Now, within these 20 children, you had 19 of them on one side and only one person on the other side. And they could not agree for close to 2 years. So now when there's dispute within members of the same family and they come for mediation, what kind of mediation do we render to them? Family-based mediation. There are mediators that can choose beyond going through the mediation training to specialize on family-based disputes between father and mother, between brothers, between siblings, between members of the same family, either extended or nuclear. We also have faith-based mediation. This comes to play when you have people of either the same faith or different faith having disputes. Usually, if they are within the same faith, you see that the tone of the mediation will be in line with their religious sect. Most religious sects have panels, have bodies, have groups that they institute for the purpose of instilling peace and harmony within their religion. So that is faith-based mediation. We also have political dispute mediation. We always hear of dispute within political parties and political groups every now and then. And after a long while of negotiation and dialogue, you discover that they've been able to mend their fences, especially when it is towards an election period. Everybody is showcasing interest in an elective office. One person is dropped, the other person is picked. Some persons may decide to leave the party, others may decide to cause issues in the party. But the process whereby persons are saddled with the responsibility of restoring peace and order in Nigeria as well. We've seen so many cases whereby political parties set up panels of elders to see how they can prevent parties from splitting. So dispute within a political setting gives place to political dispute mediation. Workplace mediation comes to play when you have disputes among individuals of the same vocation, individuals of the same profession, individuals that work in the same place, in one unit, in a different unit. When the disputants are connected professionally, when disputants are connected by the vocation they do, and disputes occur, we have individuals that have been trained to manage workplace disputes. In managing workplace disputes, the ethics of the profession cannot be taken away from the mediation process. So you need someone that understands the ethics and the dynamics of that specific job schedule to be able to bring in and assist parties in reconciling them. In most companies, you have the human resource person, you have the counseling department, you have the conflict resolution unit. These are persons that assist the organization, not forgetting that when there's dispute within an organization, the corporate goal of that organization cannot be achieved. We have mediating medical disputes. We have peer mediation. Now, peer mediation is usually a mediation process that is carried out among people of the same peers. You discover that what is unique to a particular age grade may not be unique to another age grade. So those that have been trained with necessary skills to communicate in appropriate terms with persons of a specific age grade, age group. Teenagers have their unique challenges. Adults have their unique challenges. Males have their unique challenges. Females have their unique challenges. In order to assist them in coping with these challenges, the process of peer mediation can be invoked. Mediating medical disputes. Usually, there are so many medical disputes. An individual can walk in and it is usually subsumed under workplace dispute. And if an individual can walk into a medical facility for some services, he or she may not be satisfied with the services rendered. Between one medical outfit and another medical outfit, there may be disputes. Now, persons that are in this field are purely medical practitioners that have the training of medicine and also have the basic training of mediation. Blending these two, they can help in bringing to rest every form of conflict. Industrial dispute, we always hear a particular group who want to proceed on an industrial action, and people swing in to make sure they can bring the tension under control. It is not just someone that specializes in family dispute, is a mediator, is into family conflict. That may not be sufficient to equip him or her with the skills to manage industrial dispute. That is a dispute at a different scale. So these different categories of dispute are like areas of specialization. Beyond being a mediator, you can proceed to understand the dynamics involved in these different blends of mediation. Get the necessary skills to assist parties at that specific level. Communal dispute means commercial dispute mediation. There's a whole lot of commercial disputes in our society. Contractual pays, both local and international, having financial undertone, having all manner of undertone. Now, persons can be fully trained to understand the dynamics of commercial dispute. You make orders for supplies. The orders do not come as at when they come. The orders may come, but the quantity you ordered may be different from the quantity you are getting. The dispute will be related to the quality of services offered. Now, there are some persons that can take advantage of consumer rights bodies to protect individuals from being exploited by different groups and associations. Under commercial dispute mediation, we have child justice mediation. Very critical. A lot of children are victims. A lot of children are vulnerable in our days, not because of circumstances that they orchestrated themselves, but because of circumstances that they do not have control over. So individuals can be trained with this patience it needs, with the detail it needs to understand the plagues that are ravaging the children of our days and understand how they can go about mediating cases that have to do with child abuse. Now, the role of mediators, parties, and mediation advocates, stroke advisors. What can mediators do? What can parties do? What can mediation advocates do? What can mediation advisors do? When parties come for an ADR process, their intention is to cast their problem on the process providers. They cast their problem on you as a service provider, thinking the solution is in your hand. But the process of ADR makes us understand that everybody has shared responsibility. Basic home economics will be told the duty of the father, duty of the mother, duty of the children. So it is in an ADR setting. The mediators have a role to play. The parties also have roles to play. The mediation advocates or mediation advisors have roles to play. Who are mediation advocates? An individual can take training to become a mediator and can proceed at a higher level to undergo another training that makes him to become a mediation advocate, one that will advance the cause of mediation. All parties must understand that they must be committed to the process of peaceful resolution. It is not for one person. All hands must be on deck. And a conducive environment for mediation must be identified. No matter how good your skills are, no matter how excellent your knowledge is, when the space within which that mediation exercise is being carried out, when the environment is not conducive, you may not be able to arrive at a resolution. Because when the mind is not at peace, it's not well relaxed, there's no way they may give in. That is why when you see an ADR setting, it's usually comfortable. Some centers go a little further to provide parties with water and little refreshment, or to make them well relaxed for the process of moving forward. These are usually encouraged to create a solution for the dispute, to create a solution, to be innovative enough to chart a new course. The dispute was created with the parties and other factors. So the parties are also involved in charting a way forward for the purpose of dispute resolution. The place of documentation cannot be overemphasized. In the process of ADR, from the beginning to the end, there's always documentation. Documents are taken, the particulars of the parties are taken, the progress part time are taken, decision reached at every point is usually taken. And if there's the need to pay visit to locals to a particular site, all those are well documented. And at the end of it all, if it is a mediation and parties successfully resolve, it will also be documented in form of settlement agreement, in the case of arbitration, and award. There must be proper documentation. If a process is held, if date is being held, for mediation from the beginning of the process, when people come, they must express their thoughts. Why are you here? What are the issues? It must be well crafted. And after proper documentation at the initial stage, we have filings. The claimant meets their filing, the respondent meets their filing, and at each point, they need to even fill confidentiality form, agreement form, and at the end of it all, there are documents that represent their interest. Parties and mediators must be patient. Like one of our mentors said, you must be patient, you must be empathetic, and you must be confidential. Whatever people say must not be re-echoed by you outside. You must understand, you don't rush a process. It's not a jacket, it's not a straight jacket bullet. When people discover that you are not patient, you are not empathetic, they may not be able to open up to you. We discover that most times what people complain to be the problem may not actually be the problem. Most times you are faced with parties. The claimant makes their submission, the respondent makes their submission, and when both sides finish speaking, You cannot even tie together what each party has said. One is facing the left, the other is facing the right. But when you are patient and ask open-ended questions, just one statement from a party can give you a clue on what needs to say and what needs to do. So you must be patient. You must not be judgmental. The person may be from a different religious sect, or the experience that they are narrating, you may have experienced it before. You must not be traumatized and bring your own personal opinion on them. Be patient with them, understand them, appreciate them, inspire them. When one party is speaking and you are smiling or you nod your head, make sure when the other party is speaking, you also smile and nod your head, not to allow any of them feel you are becoming partial. We must be realistic and possess a good subject of the matter. As a mediator, you must understand the underlying facts of the matter, and you must manage the stages of mediation professionally. It may get to a point you may need to break to caucus. That is, you need to excuse one party, please, if you don't mind. I would love to meet with this particular party, discuss with them, understand what the issues are. There may be the need to excuse the other party. Or when you are in a session and it is inevitable that there's a stalemate, you may need to end that session at that point and adjourn. You must understand how to analyze conflict, because in conflict analysis, most times you have the needs, you have the interest. It is the interest that matters, not just the need. Somebody will say, I need 5 million naira. How realistic is that demand? Unlike litigation, you are free, the scope of demand is endless. But in ADR process, we must be realistic enough to understand what is most appropriate for the parties. A mediator must understand personality types and how to apply them to parties in a view to arriving at an amicable settlement of the dispute. Some individuals, the underlying factor of fueling conflict is incompatibility in their personality types. There are some persons, they are Dr. Professor ABC. When you call them Mr., it annoy them. When you call them doctor, it may annoy them. But when you combine both doctor, professor, you see how excited they are. That is why most times in beginning an ADR session, you allow parties introduce themselves and ask them, how best can I refer to you throughout the course of this session? They will tell you how best they want you to address them. And that can just be a way to move ahead. Know what they like. Some parties cannot speak so much. Some can speak very well. Some are eloquent. Others may not be eloquent. When you have people on these two divides, you know how to balance the power ratio among all the parties. We cannot spend all the time explaining all of this. And that is why I need to appeal to you. In Shati, we have our settlement R. We also have different slots for training. Please connect with Shati and take advantage of our settlement R, our full webinars, our trainings. And I do know that in no distant time, you being a mentee today would also become mentor to other mentees. Thank you for listening. I appreciate you.
Yeah, thank you very much. Thank you very much, sir, for that. Can you confirm if you can hear me?
Yes, please, we can hear you, sir.
Kindly confirm if you can hear me.
Yes, sir, we can
hear you, sir. I can hear you, sir.
Okay, thank you.
We
Thank
can
you.
hear you.
Thank you. Thank you very much. So I thank all our mentors for their presentation. We will soon go into the session of question and answer, but let me just comment briefly on the presentation of the two groups. They have done a very wonderful job, and they have made some research. And then for group one, I discovered that in the course of defining some of the processes which I believe must have been explained in the course of our presentation, the definition of mediation was not properly captured. So, but I believe that we have taken care of that. So, negotiation happen between two parties when the parties are not able to, that's parties to the dispute, and when the two parties are not able to resolve their disputes, then they need the help of a third party neutral, which can either be in mediation or arbitration. So actually, mediation itself is an assisted negotiation. So you are negotiating, but you need the assistance of an expert, a third party, a neutral who is not partial, who stands in the middle and help parties to resolve. So they have done a wonderful work, and they have drawn our attention to some of the principles of mediation, you know, voluntariness and impartiality, you know, and all of those things. That is very, very wonderful and commendable. And so, and they also draw attention to the recent case between Nigeria and these white people, you know. So when you have time, you can take a look at that. It will be very, very interesting to know the facts of that case. That's an arbitration matter. So thank you very much for your presentation, Group 1. We have fixing some of the things that needed to be done in the course of our discussion. And then Group 2, you have also done very well. You've added to what Group 1 has done, and then you've helped us to understand that there are legal frameworks upon which this ADR we're talking about, mediation and the rest of it happen. Number one, law is the Constitution, and that Constitution is very, very important. Any other law that is inconsistent with the provision of the Constitution goes to no issue, as in is null and void. That is what is expected. Then we now have the mediation and the arbitration, and the Mediation Act of 2023. These are laws. Group 2 has drawn our attention to those facts, and we are very, very happy and excited to have that. So, Mr. Dennis.
Yes, I can hear you, sir.
Over to you, please.
Thank you so much, Mr. Nacham, for hosting, or rather moderating that segment. Thank you so much for stepping in and doing due justice to the topic. I also want to thank all our mentors who also contributed and who took out their time to give proper explanation and do due justice to this topic. All right, we'll be going to the last but not the least of the segments for today, and that is questions and answers. Right, I'm sure during the course of the research, our mentees, Yupo, had the opportunity to stumble across some questions, and during the course of the session, obviously there may be one or two questions that you may have from everything the mentors have said. Our mentors are available, they are set, and they are ready to answer and take questions. So please, if you have a question, you can just raise your hand, indicate, and then we'll direct your questions to the mentor. So is there other questions? You can also post in the chat box so that we can see them, read them out loud, and allow our mentors to give light to those questions. So please, are there questions? Mentees, I want us to have a very, very engaging section here, right? I'm sure we learned quite a lot, right? For those who's okay, yes, I can see a hand up already, Mr. Philip Nwosu, right? Please, you can go ahead and ask your question.
Okay, good evening. Thank you very much to the moderator, and thank you very much to all our mentors so far. So I want to ask a very quick question because time has been fast spent. So to the best of my knowledge, I know that we have specialized institutions that give training on arbitration. We have the CIR, we have NICAB and the rest. Then we also have institutions that give training on mediation like ICMC and the rest. But I'm not aware if we have an institution that gives specialized training on negotiation. So my question is basically, please, is there any institution that can give specialized and certified training on negotiation, how you can become a professional negotiator? And if there is, how can we just link up to them and get their services? Thank you.
Thank you so much, Philip, for that question. we'll be throwing this question over to our mentor, Mr. Nyacham. Please, if you can you help us with that? Are there structures that people can go to learn negotiation and also get certifications for that, sir?
Okay, Mr. Samuel, is Mr. Samuel with us?
Yes, I'm here.
Please, go ahead and answer that question.
Thank you so much, sir. Now, if we go through the presentation we made much earlier, you could see the name of two. Please confirm. I hope I'm being heard.
Yes, sir, we can hear you, sir.
Yes.
Now, you will discover that there were two institutes that were being mentioned. I don't know if Mr. Nacha can help and project that slide. We have the Negotiation and Conflict Management Group. We also have the Institute of Chartered Mediators and Conciliators. Now, looking at the profile of Mr. Nachang and some of our mentors, it is obvious that they have certifications on negotiation. So yes, there are institutes that train on negotiation. There are institutes that certify on negotiation. What we are going to do, we're going to do a link. I think we are about entering February, we're entering into March. Between now and 2 months, in 2 months' time, those that have interest in this area, I'm sure you can liaise with Mr. Nachang and we will do a comprehensive list and make available to you. So yes, you have trainings on negotiations, you have certifications on negotiation, not disputing the fact that we earlier said that most of these spectrums do not run in isolation. They are all intertwined. While you are doing mediation, you are also being trained on negotiation. There's one arbitration training that I took, and while people were going through arbitration training, I was opportune to anchor the session that talked about negotiation. Because in all spectrums of ADR, we have negotiations involved. So the answer to your question is yes, and we can easily give you a list of each and every one of them. For the sake of time, I'll stop here. Now, for those that I can see a message on that, I'm interested in the training. Please make sure I'm sure Mr. Nachang will drop the social media handle of SHATI, Settlement House Training Institute. Make sure you follow us on that, on our various handles, and you'll be kept apprised of all updates. Thank you.
Okay, so thank you very much, Mr. Samuel. Now you see, when you are doing some of the trainings, in those institutes, just as Mr. Samuel has said, you will get trainings on that. So, but then if you check our website, Settlement House ADR Training Institute, you will see that we have training specifically on negotiation. So we send you the our website. You can check it, and then for those interested in training, you can. That is coming up in the 19th of this month thereabout. You can just chat me up. Okay. I will give you. Okay, so now that is that. Now you see, Settlement House provides also trainings basically on negotiation, because as I said earlier, Settlement House is an institution that trains and certifies in all the alternative dispute resolution mechanisms. Unlike some of the institutes who seems to be specialized in either arbitration or mediation, even from their names, Settlement House is registered as an ADR training institute. So we do training in ADR registry, or secretariat services, ADR. We do training on negotiation. We do trainings on emotional intelligence. We do trainings in mediation. We do trainings in arbitration. All of them are certification training. So you can look at that. Then you can see that institution that we quoted in the first time is called Negotiation and Conflict Management Groups. So you see, beyond Nigeria, you can now go beyond other, you can go into other countries, you know, outside the countries where you can take trainings like that. Now you also have Lagos Business School. They also take trainings in negotiation. They do trainings in negotiations. You also have some institutions like universities that also offer trainings, you know, under some of their centers, you know, they offer training in negotiations. So Mr. Philip, if I'm not mistaken, I hope we have attempted your question.
Yes, sir. Very well, very well. Thank you very much. I really appreciate the clarity. Thank you.
Hello?
Yes,
yes.
sir. Yes, sir.
Yes.
Okay,
you can reach out to me. Yes. Thank you.
Thank you so much, Mr. Thank you so much, Mr. Samuel, for helping us answer that question from Mr. Philip. All right, please, can we have more questions from our mentees? Please, I want to see questions. This is our opportunity to really engage our mentors to see if they can clear up the air on some questions that we may have. So please go ahead and ask your questions. I want to see hands. Mentees, come on. Ask questions, ask questions, ask questions. I'm sure there are those who have questions on today's topic. Can we have more questions? Okay. While we're waiting for our mentees to ask questions, right? I'm sorry for my video not being okay. It's actually on. It's lighting in my room. That's it's the power. There's current power outage where I am. So please, we'll be taking questions. We'll be taking questions. Mentees, please go ahead and ask your questions. And okay, I would like to put out a question while we wait for our mentees to ask. All right, so we talked about how that mediation and arbitration and everything that concerns ADR is more of matters that pertains settling cases out of court, right? Where we have scenarios and circumstances that we want to end in an amicable way, right? So are there situations or circumstances or cases in that sense that we cannot necessarily settle using ADR? Are there cases that that we would recommend that, okay, because of the nature of this kind of case, it should go to court and not be settled under ADR like structures? Are there mentors? Okay, do we have any mentor on call who had my question?
Yes, we are here. I wouldn't know who you're directing that question to. I think
yes, sir. Okay, Mr. Samuel, if you can, please, can you help us with that question?
If I got your question correctly, I suppose you want to find out, are there matters that are ADR compliant and are there matters that are not suitable for ADR process? Is that your question?
Yes, sir. That's exactly my question, sir.
Thank you. Thank you so much. In a proper ADR training, you'll be made to understand that there's what we call ad hoc ADR processes and institutionalized ADR processes. Now, taking mediation as it were, in almost every state in Nigeria, we have what we call the multi-dock courthouse. Now, ethically, there's no matter that cannot come or be subjected or suitable for ADR. It is usually at the instance of the parties. Now, taking mediation as it were, for mediation, parties must submit to the process of mediation. Basically, there are three ways a matter can come in. Matter can come in through walk-ins, individual walking to a dispute resolution center, or there's what we call direct intervention. A dispute resolution center can discover conflict between individuals and make direct attempts at resolving them, or there's what we call court referrals. A matter can be going on in a court, and a high court, a judge looks at it and discovers that I think these two individuals can sort themselves out and reflect them for mediation or arbitration as it were. So any matter without a criminal ingredient is suitable for ADR, basically. But even looking at some criminal matters at a lower level, there's restorative justice as part of the ADR spectrum. Restorative justice is a process whereby a victim and an offender have the opportunity to make restitutions between themselves. We have some minor cases. So cases that have no criminal elements can actually be considered suitable for ADR. Cases that you discover that both individuals can sort themselves out, there's nothing we cannot talk about. There's nothing we cannot resolve. Most matters are easily resolved when the parties are at the forefront without the need of an intermediary. So basically, I hope I've been able to answer your question. When a dispute has no criminal elements, it is suitable for ADR.
Okay, thank you very much, sir. We have other questions on the chat group. One of them is Mr. Dennis.
Yes, sir.
You know, we are in this together.
Yes,
So we have, he said, the question from Emmanuel Joy, it says, please, how is the judge involved in the process of ADR? Number one, when parties have discussed, let's say two people discuss something and agree, and they decide to write it down, you know, that is an agreement that can be enforced it, or during a mediation session, parties have agreed on terms and say, I'm going to pay you your 5,000 naira in 2 installments of 2,500 naira each. When you finish these things, for court-connected ADR centers, you know, you will go to the multi-door court house and say you have an agreement and you want to enforce it. You know, so if you take your agreements there, they are going to take you before an ADR judge who is going to look at what you have and then ask the two parties involved and say, is this what you have agreed? If you say, yes, that is what you agree, then he's going to stamp it and make it become a consent judgment. With that, you can enforce it. So that's one of the role of an ADR, a judge involved. So you have ADR judges. Then you have judges in court. Sometimes the matter will be in court. Parties, either with the referral to multi-door court house or on their own. You see, lawyers will say, okay, let us go and discuss settlement, and parties settle. When they settle, they will bring the terms of settlement before the court and say that this is what the parties have agreed concerning their dispute. And the judge will also, in a normal court, confirm if that is the position from the lawyers, if they have lawyers, or from the parties, if they have, or if from both the parties and the lawyers. And if that is done, the judge will now stamp that or enter it as a consent judgment. And once that is done, that matter has come to an end. You cannot even appeal against it, because it will be very difficult for you to show that there is fraud or that there is misrepresentation, because the judge has performed his role. That's on that. I believe that I've answered you, Joy. Then I was sought for permission to, okay, we have sent also the settlement our group, if you can join. Then someone is asking, what is the difference between ICMC and NICAP? ICMC is an abbreviation. The first letter is an abbreviation that has to do with the first letter. They pick the first letter of each word in the name of an institute. So ICMC stands for Institute of Chartered Mediators and Conciliators. Busolami, are you with us?
Yes, I'm with you, sir.
Yeah, so ICMC stands for Institute of Chartered Mediators and Conciliators, and they pick first letter of each word. So if you are trained by ICMC, they say you have, depending on the level, whether associate or member or fellow, you can use A for associate, M for member, and F for fellow of this ICMC. Name of the institute, you are an associate of ICMC. That's the meaning of that. So for NICAP and ICMC basically trains only in mediation and conciliation. So, but with the coming into being of the mediation, the Arbitration and Mediation Act, which replaces arbitration. So you see that we do not have issue of conciliation again, although they are subsumed inside mediation now. So that is it for ICMC. Then you now have NICAP. NICAP stands for Nigerian Institute of Chartered Arbitrators. It is a Nigerian origin. Is a Nigerian Institute of Chartered Arbitrators. So, but because of some issues before, now when you are trained with NICAP has to do with, they do more of arbitration, although they also do some trainings in mediation. So when you are trained with that, you become you will become an associate or a fellow or a member, a full member of NICAP. So, but what they use as abbreviation is M as for member, and then N, that's MC instead of CI app, which is for the foreign one. You now have M member chartered app, that's C app. That is what they use for their own abbreviation. I hope I'm able to attempt your question on the difference between. So ICMC trains only in mediation and conciliation, while NICAP trains in arbitration mainly, but sometimes do some training in mediation. But Settlement House, which is Shati trains in all mediation, arbitration, negotiation, and all other things. That is the way it is registered to carry on ADR training. So with that, I think we have attempted that question. So we now have other questions here. I don't know whether Baratu is online. Mariam, the question here is, when an award is being awarded to one party in an arbitration process, can the other party contest or appeal? Can the other party contest or appeal as regards to the award? Baratu, are you with us? If you are there, I would like.
Sir, I don't
Baratu,
think
are you?
so, sir.
Okay, she's not around.
Okay,
I'm
okay,
around. I think the network was bad. I wasn't
Okay. Can
hearing
you
you.
attempt that question?
Can you repeat
When
the question?
an award is being awarded to one party in an arbitration process, can the other party contest?
Okay, quickly, usually before you go to arbitration, the parties are the ones who agreed themselves to go to arbitration. So when an award is given against a party, the party cannot contest that award because it was his agreement in the first place to go for the arbitration. And that's the rule behind it is that parties are bound by their agreements. The only time that a party can contest an arbitral award has been provided by law, perhaps where the arbitrator misconducted himself in any way as provided. then the party can contest the award, but he cannot contest the award on the basis of the fact that the award was against him. Thank you.
Or that he wants to go on appeal. You cannot appeal an
No,
award.
you can't appeal
You
an
can
award.
only apply to set it aside. That is why you need to go into proper training and certification training to know what is involved, what you need to do, and what you ought not to do, so that your awards, when you deliver an award, it will not be set aside based on maybe one or two reasons, you know. So I don't know, is Lolia still here? What of Mariam? Okay, Mariam, are you here? Mariam? Okay. Now the second question is, during our course, Mr. Samuel mentioned the fact that negotiation process the outcome of a negotiation process is not enforceable. Please, can you enlighten us more on that? Mariam, are you there? Okay. Mr. Samuel.
Yes, sir. I'm here, sir.
Yes, somebody is holding you by your words. Explain.
I want to appreciate the name that actually asked that question, Zoom user. Let me appreciate Zoom user for that question. I think I started by saying that negotiation can be formal or informal. I think I actually said that. I'm not too sure if I said that the process of negotiation is not enforceable. I was trying to paint the picture that it's what happens on a daily basis at an informal scale or at a formal scale between parties. Usually, multinationals, corporate bodies can resolve dispute through the process of negotiation. Now, at the stage of negotiation, whatever is the outcome can be escalated to become a consent judgment through the process of mediation. Let me quickly say this here now, that usually most times parties that have disputes can come to a common ground through negotiation. When they are done with their negotiation stage, they now have an agreement. At that level, they can come for mediation with that agreement, and that agreement can become a consent judgment. In other words, at an advanced stage, mediation is not just open to parties that are having dispute and seek experts to resolve them. Some persons, through the process of negotiation, with the aid of a counsel, with the aid of a negotiator, can resolve issues and walk into the mediation venue, walk into the multi-door court, walk into the mediation institute with a document reflecting the agreement. That document cannot be processed into the form of consent judgment. It is consent judgment that can be enforced. Because whatever both parties agree on and document, it may not be enforceable. But when it becomes a consent judgment, so individuals that have personal private dispute resolution institutes can intervene between disputants, come to a common ground, get a document, bring that document, walk into any multi-door courthouse with that document, and the multi-door courthouse will assist them in adopting that agreement to become a consent judgment of the court. And by so doing, that judgment becomes enforceable. For anything to be enforceable, it must have the backing of the law. Where you have the judgment of the courts, you also have consent judgment from parties. The difference is when you go through litigation, the court is at the judge can decide to make a verdict on the matter. It has the backing of the law. But when you go through ADR, especially mediation, it is the parties that decide what they want. Their decision is binding consent. Whatever they agree upon cannot be processed to the court. And an ADR judge can endorse it, it now becomes a court judgment, a consent judgment, and that judgment can be enforced. I hope I've been able to answer your question, Zoom user. Thank you so much.
Yes, sir. Thank you, sir. Thank you, sir.
Thank you so much, Mr. Samuel. Thank you so much, Mr. Nyacham, for helping us through our questions, and also Ms. Baratu for helping us through the question and answer session. If in the absence of no question, or in the absence of more questions, we'll be drawing the curtain on today's session. Are there any questions before we draw the curtain on today's session? Any more questions? Okay. In the absence of any more question, I would like to say a big thank you to Mr. Nyacham for co-moderating with me. I would like to also say thank you to Mr. Samuel, Ms. Baratu, Ms. Lolia, and Miss Lolia and Miss Mariam in Essential. We want to say thank you to the Settlement House ADR Training Institute. You can follow them on their LinkedIn page. Mr. Nyacham just posted their link to their LinkedIn page, and you can also register and follow the Settlement House ADR. His phone number is there if you need further training on arbitration, on anything as pertaining ADR, right? You can reach out to Mr. Nyacham, or you can also reach out to me, and we'll do well to connect, make the necessary connections that you need for those training. So once again, I want to say thank you to all our mentees and our mentors for putting us through this wonderful 2-hour session that we just had. I'm sure our mentees have learned a lot. I would like to encourage our mentees to reach out, or rather to follow. This class is being pre-recorded, right? You can go to our YouTube page and then you can find the video, right? You need to refresh your memory on what our mentors have said. You didn't get enough in your notes and you want to learn, you want to listen more, please go to our YouTube page as JIIPCC, PCC, and you would get access to this class. So I would also like to ask Mr. Nyacham if that it will be possible, right, for him to share the slide he used today for the class, if that is going to be possible, right, so that we can also share with our mentees. They can further go through today's what was presented on today, and they can redigest everything that has been said. With that, once again, thank you to our mentors. Thank you for everything that you do for us. Thank you to Settlement House ADR Training Institute. And with that, we've come to the end of today's session. We look forward to seeing you all in the next class, which is next week, Wednesday, same time, right? Other notification and other announcements will be passed in your WhatsApp group. Thank you very much, and enjoy the rest of your evening.
Thank you. Before you go, I saw I can see one of our mentors came in. I don't know whether she has been there. Eunice Olatunji, please, thank you for joining in. Just to acknowledge and appreciate you for tuning in. Thank you very much, Eunice. If you can hear me, thank you.
Yes, I can hear you. Thank you, and well done, everyone.
Yes,
thank you. Thank you very much, Ma. Thank you very much, everyone. And good night, everyone.
Good night. Thank you.
Good night, yeah. Thank you so much.